An important part of the incident response when an organization thinks it might have a data security breach is the collection and evaluation of evidence. Just because a laptop computer can't be found, for example, doesn't necessarily mean that the organization has conclusive evidence that it has in fact suffered a data security breach for which it must give notice under different kinds of laws. Therefore, as an organization sees that it's got an incident that needs to be evaluated more carefully, the organization is wise to follow a professional, disciplined approach to gathering evidence and then evaluating that evidence to conclude whether, in fact, a breach has occurred for which the organization needs to give notice. An important factor to bear in mind as an organization conducts an incident response is that the legal adversaries of the organization may disagree with the organization's own evaluation of the incident and evaluation of the evidence. For example, a legal adversary could be a class action plaintiff's lawyer, it could be a government regulator. These adversaries, if they were able to gain access to the organization's full investigative details, might say, wait, you had all this information, it shows that you had a breach and you should have given notice, therefore you're bad and we should sue you or punish you. On the other hand, from the point of view of the organization may actually review the same evidence and conclude, no, there was not a breach under law, therefore we should not have given notice. So here's the point. When an organization is conducting an incident response, it's often wise to ensure that all the details of that investigation are maintained as confidential. And so ways to maintain confidentiality would be, one, ensure that all the investigators have signed the appropriate non-disclosure agreement, but two, an organization may be wise to actually reach out to legal counsel and have legal counsel engaged in the investigation. And oftentimes, if counsel is engaged in the investigation, then counsel can cloak the investigation in something that's known as attorney work product. Attorney work product is very similar to attorney-client privilege. It's a form of confidentiality that can be enforced in law. So if an attorney is substantively engaged in an incident response and evidence is collected and the organization doesn't want the results of all that investigation evidence to go to legal adversaries, the attorney work product doctrine may well help the organization achieve that goal. In order to learn more about the course that I teach at the SANS Institute, you can click the link below. Also, another link below provides more information about me and my work in private practice.